Hello and welcome to another Legal Talk right here on eRadio with myself, Jan, and Hahn Attorneys. Today joined by Merilynn Plessis from the firm. And another interesting and rather serious topic today. My boss is abusing me verbally. What can I do legally without losing my job? Woo. Now, I can think of quite a few people currently stuck in that situation and how uncomfortable that must be. Merilynn, hello and welcome.
Hi, Ian. How is things there?
It's lekker. I see it's going to get really cold and wet from Thursday here in our area. So you're probably sending your weather down here, or is it not from you guys?
Goodness. No, it's definitely coming from our side. We've had a lot of rain in the evenings, and in the day it's as if there's not a cloud in the sky, and then in the evening it's as if it's been raining for, 2 weeks.
Goodness gracious. Okay, yeah, so you're probably sending it down, but I always like rain. I don't complain, and it is basically winter.
Me
so,
too.
Yeah, that's fine. No, it's nice. But anyway, so Merilynn, today's topic is pretty serious. I mean, what on earth would you do if your boss is abusing you verbally? And I mean, obviously you want to do something, you want to take action, but you also don't want to lose your job. So, I mean, that's a very serious catch-22 situation.
Yes, obviously, there is a lot of management that does that. I mean, micromanaging, it's a form of a bigger, greater problem, I would say. But luckily, there is a solution to all problems. In our law, we don't have a formally recognized step, but the standard practice that companies use, and we've all have heard it, is called a grievance. Mm-hmm. So nowhere in the law does it make it an obligation for companies to have grievance procedures, but I can guarantee you that it's become practice. I would say 80% of companies do have the grievance policies in place. And the grievance procedure is actually quite nice for exactly these type of situations. Grievances usually have provisions where they protect the employees from any form of discrimination or, I would say, punishment because of bringing such a grievance. But what should be very important, and it should be noted from the beginning, is that a grievance can only really be followed if you yourself have already done everything, let's say, in your power to kind of resolve this issue. So your first point of recourse would be obviously to approach management, to approach that employer or manager who's abusing you, and address the situation with that manager. And if you then don't see that anything improve, sometimes you'll have it that it may actually increase or worsen, then the second point of recourse is then to lodge a formal grievance. That formal grievance is kind of like an internal dispute. So if you would think about you going to CCMA, that's an external dispute. A grievance is an internal dispute. So what that just means is that the next the line manager, so let's say, for instance, I have a manager, my manager is verbally abusing me, and he has a manager, and the manager above, etc. So what the grievance does is that is addressed to your manager's manager, so that's the next level. And it places the obligation on that manager to resolve the issue. Usually it's done through mediation where the top manager sits with the parties and tries to resolve it. Other situations can be, for instance, we have many times where companies approach us independently and asks us to sit in and mediate to resolve the issue. So the grievance procedure is actually just to resolve that issue without having anyone I would say discriminated against or punished. In fact, You cannot discipline somebody during a grievance or as a result of a grievance. So let's say, and vice versa. So let's say you've been disciplined and you're unhappy, and if the disciplinary is correctly has been approached correctly, you can't use a grievance, and vice versa. So that's kind of a very nice tool to use. And the second thing that I think is very important is, even if an employer does not have a grievance policy, the nice thing is that you have the Employment Equity Act. Now, last year, they actually published a code of good practice. It's called Code of Good Practice on the Prevention and Elimination of Harassment in the Workplace. So what this does is it now prohibits these kind of conduct from managers. A very interesting term that they use is they actually will use such a situation to call it harassment. So they'll consider that as harassment, and then that person will be in breach of the Employment Equity Act. And all that means is, and an additional thing to say is that all employers have an obligation to make sure that all workplaces are harassment free. So that is a positive obligation that's already, I could say, protecting you. Is to say that no matter what, your employer has to treat you with dignity and with respect. Should they not do this, let's say in the extreme cases, you would be able to approach the Commission of Employment Equity, and they come and give findings, and they'll have a compliance notice, for instance, but that would be taking it to the extreme. So there you go, all in one breath.
Shame, Merilynn, and I know that you don't have a lot of breath because you've been a little bit ill. Sorry, man. I know I should have given you more breaks. No. This is good exercises for the lungs to get back where it needs to be. Yeah. Okay. So that kind of solves the situation. There's a lot of ways to go about it. I suppose it gets a little bit more complicated when the boss is actually the owner of the company and it's a small business. That could get a little bit more closer tricky. And personal and tricky. Hey.
So yeah, but in that situation, that's a good question, to raise is, what if, my boss is the highest up? Well, then unfortunately, and I'll always say your first point of recourse is to make sure that internally you have done everything that you can in your power. And I don't think that not everybody actually wants to hear that, because nobody wants to go and sit and accuse your bully or your bullier and the bull. But that's an unfortunate thing is if you have approached your employer or the management first and it's still not resolved, I would say in that situation, you would have to then go to the CCMA. Otherwise, the employer, yes. So in that type of situation, it's an unfortunate one. But the thing is, that's also the reason why all these kind of guidelines and acts forces you to first deal with the issue. Because many times I'm well in my 30s, and I can tell you many times it's as a result of misunderstandings or miscommunications, and it's something that can typically be resolved without even resorting to the law. But I would say that, even if, let's say it like this, and this is what I always ask my clients is, would you still want to be working with somebody if not resolved?
Yeah.
So the thing is, you either resolve it or you make that decision of, can I work with this or can I not? If I can't, I feel like I'm being constructively dismissed, which means, and that's a topic for another day, which means that your working environment has become so hostile and it's become so bad that you've had no other choice than to resign. then you have a case to bring under the CCMA. But, my first point of recourse is to sit with that manager, sit with the boss, and find out and try and resolve that. 80% of the times your problems will be resolved at that point of recourse.
I know of people who actually sat down with the boss and then it goes well for a couple of months and then the problem just starts again, because we have to understand as well, some personalities just don't gel, they don't work together, that is a fact, unfortunately, and that's where HR can also assist if it's a bigger company, I suppose. But if it doesn't work out, it doesn't work out, and if you both really tried, I guess it's time to look for another job, even though they're very scarce.
Yes, and the thing is, Jan, that's the whole thing is, by speaking to that person, you're able to ascertain whether or not it's the problem, where the problem lies, and is it something that can be solved or not. A person after that point of resolution, and obviously, with mediation and with CCMA and all of these things, that's what people look at is can this problem be resolved, or is it something that I need to move on from? And yes, so I know it's a very tricky situation, but the fact of the matter is, and that's the nice thing is if you really sit and listen and speak, you will find out what the problem is. And the best is then to work together and resolve this problem, or to decide to make your next move.
Merilynn, you're a star. Thank you so much. This has been very insightful once again. And I thank you for your time and for sharing your knowledge with us here on Legal Talk.
It's a huge pleasure. It's always a big pleasure speaking to you and the public. Thank you.
Thanks, Merilynn. Take care.
Okay, take care. Bye.
Are you or your business in trouble and struggling to find a solution? Call Hahn & Hahn Attorneys as we assist clients in finding solutions. We specialize in consumer and food law, commercial and construction law, forensic investigations and administrative law. Visit hahnlaw.co.za. That's HAHN. We assist clients nationwide. Hahn & Hahn Attorneys, because we care. Don't miss Legal Talk with Hahn & Hahn Attorneys, Wednesday mornings at 10 on eRadio.